represented by Mr. Brockler, Mr. Orman, Ms. Tisch-McGuire, Mr. Edson, and Ms. Pearson. We are outside the presence of the jury. I have a note from Juror 901, which is a follow-up to the colloquy that I had with her yesterday. It reads as follows. And before I read it, I should tell you that I will mark it as question form number 183. I found out more details of my brother-in-law's accident yesterday. He was actually shot 3 times during an attempted robbery. This was in Denver, and he will remain at Denver Health for a while. He is okay, but critical. I wanted to tell you up front about the whole story. I know I can still be fair and impartial about this case, and the word no is underlined. What happened to my brother-in-law will not take my full focus away from my duty here. Please let me know if you have any questions. I wanted you to know the truth about this situation firsthand, and I hope that I can remain on this jury. Thank you. Sincerely, Juror number 901. Are the people requesting that the court take any action based on that note, Mr. Orman?
No, Your Honor.
Is the defense requesting any action, Mr. King?
We have a moment.
Yes.
Judge, we do think that we need to question her to find out more of what the circumstances of this situation are, to see how it might affect her jury service, potentially. And we're not looking for anything specifically. We just think we need more. The court should have more information.
You're seeking more information about the incident?
Yes.
I don't know that it's necessary, but I'll err on the side of caution and I'll question her. Let's bring in juror number 901, please. Yes.
Approach real quickly.
Yes. Good morning.
Good morning.
The record should reflect that juror number 901 is now present in the courtroom. I read your note that you wrote earlier today, which is a follow-up to the discussion that you and I had here yesterday.
Yes.
And first of all, I want to thank you. I appreciate your candor. I'm sorry that one of your relatives is in the hospital.
Yeah.
Before we proceed, are you okay discussing this in open court?
I am. It's
Okay.
fine.
All right. I just wanted to find out more information about the incident that your brother-in-law was involved in yesterday.
Okay.
What more can you tell me about
Well,
what happened?
he was a little groggy, but he said it was about like 3 or 4 in the morning. He couldn't really remember. He stopped at an ATM in Denver, and a guy came up to him and asked for a cigarette. And he didn't have any more, so he kind of offered the one he had and was like, look, this is all I have. The guy went to grab for the cigarette and pulled a gun on him. And then he fought the guy, grabbed the gun, and it shot him in the leg, in the shoulder, and in the chest. But he's fine. And he tried to chase him, I guess, but ended up collapsing next to his car, woke up, got in his car, drove himself to Denver Health, and then told the cops there. And that's really all he kind of remembers. So.
Okay. This all happened yesterday morning,
I believe it was yesterday around 3 or 4 in the morning.
and you found out about it later in the day?
I did. The family only told my husband that it was an accident. So I was assuming car accident. So I just knew it was bad, and he was critical in ICU. That's all they told me.
This is your husband's brother?
It's my brother-in-law, so it's my sister's husband.
Oh, okay. Anything about that incident that you think would affect your ability to be a fair and impartial juror in this trial?
Absolutely not.
Okay, and you seem certain of that?
Yeah.
You're very confident about that?
Oh, yeah.
Anything about that incident that you think would influence any of the decisions that you have to make in this case?
No, not at all.
Will anything about that incident influence or affect in any way your deliberations in this trial?
No, it won't.
Do you have any concerns that you want to talk to me about?
No, I just wanted to be upfront and honest. The moment I found out last night, I was like, first thing in the morning, I'm letting him know. So.
Did you go to the hospital yesterday?
I did. Thank you very much for that.
It's okay.
Good to see him.
It's your relative, and so I can completely understand.
Yeah.
Again, I'll just caution you when you go to Denver Health
Okay.
Medical Center that you don't go out of your way to make observations or try to do any investigation or try to obtain any information in relation to this case, okay? All right. And if at any point something happens that you think you need to tell me about, even if it's inadvertent, while you're at the hospital, then make sure you tell my staff, please, so that they can tell me, okay?
Okay, I will.
All right. All right, let me have you step out for just a moment,
Okay.
please. Okay.
Thank you.
The record should reflect that juror number 901 has now stepped out of the courtroom. Is there anything else that you would like me to ask her, Mr. King?
No, thank you.
All right, in light of that information, is there any action that you are asking the court to take at this time?
No, sir.
I'm inclined to ask her not to discuss this with the other jurors. Is that okay with both sides?
Objection to that.
All right, let's have her back, please.
Almost let in the troops. Sorry.
We're not quite ready yet for all of
Sorry
them.
about that.
That's okay.
They were following me.
All right. I just wanted to ask you not to discuss this incident involving your brother-in-law with the other jurors.
Okay, the people in my room already know, because when
Okay.
I found out, I kind of broke down a little bit.
That's fine.
Okay.
That's understandable. Just from here on out,
Okay.
I'm going to ask that you not talk about it with the other jurors.
Okay.
Okay. All
Okay.
right. Any other concerns or anything else that you want to talk to me about with respect to this particular incident?
No, that was it.
Okay. I appreciate you being so candid with me. Thank you.
Thank you.
All right. All right. The record should reflect that juror 901 has now stepped out of the courtroom again. Are the parties ready for the jury, Mr. Orman?
Your Honor, I don't know if the court has had a chance to decide on the crime scene video, but we would want to make witness arrangements depending on the court's ruling. So if you could give us a ruling, that would be helpful.
I did. I looked at it again. I had viewed the video before I issued amended order D98B, as you know, and I ruled on the admissibility on a preliminary basis of the video in that order. And I watched it again last night, and my ruling stands for the reasons stated in that order, and also because even after the evidence that has been admitted, I'm convinced that I should not exclude it under Rule 403, and specifically under the concern expressed in Rule 403 for the unnecessary presentation of cumulative evidence. I don't believe this video is cumulative. Are there parts of it that overlap the testimony? Of course there are, but that's always the case. I think the argument that was made by Ms. Spengler yesterday is that the video is cumulative of the testimony that has been provided. But if the rule was that if there was any overlap between a video or a picture and testimony, that the video or picture would have to be excluded, then all videos and all pictures would always be excluded, because you almost never have a picture admitted or video admitted without some testimony about it. Generally, the picture or the video has to have some testimony accompanying it, explaining it, talking about it. And so the fact that there has been some testimony about the crime scene from different witnesses, in my view, does not render the video inadmissible under Rule 403. I think that the more compelling argument, which was not made yesterday but has been made before, is that the video is cumulative of the pictures that have been admitted, and Ms. Pearson addressed that yesterday, and I watched the video with that in mind, and there is some overlap between the video and the pictures, but there are some things on the video that have not been introduced through photographs or testimony before. The video is a video not only of auditorium number 9, but also auditorium number 8, and it also shows the lobby. It shows, it appears to show some areas outside the theater. It starts from the front of the theater, and it's someone simply walking the camera and videotaping the walk. But that walk starts from the parking lot into the theater through the lobby, and then it shows first auditorium number 9, then it shows, I think, some of the food concession area, then auditorium number 8. And I think Ms. Pearson made this point yesterday. You don't get the same understanding and perception of the crime scene through the video or through the pictures that you do through the videos. Through the video. In the pictures, you see snapshots of different areas of the theater, the Century 16 theater. But it's hard to, in your mind, put it all together, and that's what the video does. The video puts it all together by piecing all those snapshots together, and it gives you a better view of where everything was found, where people may have been found, and I'm talking about bodies that were recovered, some of the deceased victims who were found in the theater, and it is the best evidence, perhaps, of the crime scene. This is how the crime scene was found, and this is a videotape that is taken, as I believe, on the same day, on July 20th, so less than 24 hours after the shooting, and before some of the crime scene investigators had moved things around and had done some work in there. This is showing how the crime scene was found, where a weapon may have been found, where certain bullets or shells may have been found, where deceased bodies were found, how they were found, all those things. There are blood stains on the floor. This is exactly how the crime scene appeared shortly after the incident, and so it is very probative. And as I said, I think that there are angles that you see in the video that you don't see in the pictures, and the video pieces it all together and makes it easier to understand in terms of where everything is and the relation of the different items and bodies and different items of evidence in the theater, the special relationship between those items and the people. I think it's clearer in the video. So for all those reasons, the objection to cumulative is overruled. And let me just say that there was nothing improper about the objection. I specifically said in amended order D98B that I could only make preliminary rulings on the pictures and the video, and that if during the trial somebody wanted to make an argument with respect to cumulative evidence, that they had to make it during the trial. Yesterday, Ms. Brady made it with respect to a couple of photographs, or with respect to some photographs, and I sustained the objection in part as it relates to two pictures. I also said in the video, or excuse me, in the order, amended order D98B, that if during the trial the defense at any point wanted to object to a picture or the video and offer some other picture or video that they felt was less graphic and equally probative, or that it depicted the same thing but in a less graphic, less prejudicial way, that I would consider that. And so that was in my order, and so there's nothing inappropriate about the objection, just as there was nothing inappropriate about Ms. Brady's objection yesterday. My rulings, as I said in amended order D98B, specifically allowed for that. And so I have considered the objection, but it is overruled for the reasons that I just stated and for the reasons that I articulated in amended order D98B. Is there anything else at this time on behalf of the people before I bring the jury in?
Thank you, Your Honor.
Is there anything else on behalf of the defense before I bring the jury in?
No, Your Honor.
Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is now in the courtroom. Good morning, everyone. Good morning. How's everyone doing? Good. It's basically Friday for us. Thank you for coming in today and being patient with us this morning. At the end of the session yesterday, Ms. Data was on the witness stand, and Mr. Brockler was in his direct examination of her. And so, Ms. Data, I will remind you that you're still under oath. Mr. Brockler, you may resume your direct examination of Ms. Data.
Thank you, Your Honor. Ready?
Yeah.
Now, ma'am, you'll remember that when we left off yesterday, we had just admitted the Gmail chats, the G-chats that you and the defendant had had over the course of about 5 or so months. Do you recall that?
Yes.
Here's what I want to do before we publish copies to all the jurors to go through. I'd like to highlight certain portions of them to just allow you to provide context for what it is they're going to end up reading, okay?
Okay.
649-3, please. This is a chat from October the 11th, 2011, and if you'll blow that up for me, ma'am, I want to ask you about this. This is a text, this is a part of the chat that you got from the defendant. The reason I put this up there is I want to ask you, it says right here, you can't get enough of my sexy neo body, and in the context of the conversation, that'll be clear. What I want to ask you is, during the course of your time with the defendant, did he ever express to you any concerns about his body?
No.
Did he ever talk to you about concerns with his eyes?
No.
Nose?
No.
Hair?
No.
Teeth?
No.
Did you ever see him pull at his hair, like constantly pulling it out?
I don't remember seeing him pulling his hair.
You think you'd remember that if that was a constant
I think
thing?
so, yes.
Did you ever see any hard-to-explain bald spots on him?
No.
You can take that down, ma'am. Thank you. 649-4, please. There's a symbol, and by the way, this is from that same lengthy chat. There's a symbol here. Do you recognize that from the G-chat?
I remember that from seeing the G-chat, yes.
Now, it was in, he sends it and then later says, I'm punching a cat. And in the context of the conversation, they'll get that. But had you ever seen that symbol before?
No.
Did you know what it was?
No, I had no idea. I had to ask him on the G-chat what it was.
And is that what generated the response, I'm punching a cat?
Yes.
Okay, thank you. Ma'am, you can take that down. 649-7, please. This is from an email from GChat from October 20th, 2011. Did you and the defendant ever play video games together?
A few times.
Okay.
Computer games.
This is a reference to something called Limbo. Tell us what that is.
So that's the only game we played together. From what I remember, I haven't played it in more than 4 years, but from what I remember, it was this kind of a shadow person thing that avoids obstacles and has to solve puzzles to get to the end of the game.
And did you end up playing that together?
Yes, he had a Windows computer. I don't, and this only works on Windows.
Okay. Were you aware of the defendant playing any other video games during the time that you were together?
I remember him telling me that he played Skyrim.
What's Skyrim?
I believe it's a strategy video game where you have to slay dragons and stuff, but solve puzzles too. And yeah.
Okay, thank you. There's another portion, ma'am, on that. Now, during this conversation, and the jury will get a chance to read how this all fits in, but I want you to explain this for us. There's a discussion of phantom limbs. What are you talking about?
So, I had read this book called The Man Who Mistook His Wife for a Hat. It's by Oliver Sacks, who is a very famous neurologist. A few of the cases he presents in the book are of phantom limbs. So someone, when they're paralyzed or have a limb cut off, they can sometimes feel pain on that limb or feel that they can feel the limb still. And that's phantom limbs. And some other neurologist came up with a really good way to cure phantom limbs, and Oliver Sacks talks about that. So this is what it's in reference to.
To the extent that some of that information and others that we're going to talk about aren't contained in the G-chats, are these G-chats sometimes in reference to just conversations you'd have in person?
Sometimes.
Okay.
Mr. Brockler, let me interject if
Yes,
I
sir.
may here,
Yes, sir.
because I don't know what all you're going to show on the video screen. I want to make sure that I instruct the jury that with respect to this particular exhibit, P-TR-649, any statements in this exhibit that are not statements by the defendant, in other words, that are statements by Ms. Data, have been admitted only for the limited purpose of placing the defendant's statements in context in order to make them intelligible. You should not consider Ms. Data's statements on this exhibit for any other purpose. Does everyone understand that? Yes. Okay, and everyone's nodding their head and saying yes. I'm sorry to interrupt you. Thank you. Go ahead.
No, sir. Thank you. Can we get 12, please? Ma'am, you'd mentioned that the defendant had a sense of humor, and it seems to show up better in writing than it does in person. Do you remember that?
Yes.
Here's one portion from a G-chat from November 10th, 2011. Do you remember what this is in reference to from the defendant?
I think I asked him whether he has eaten Ethiopian food or if he likes Ethiopian food. Yeah, we were probably planning to go get food.
Now, this is probably a good time to ask you, was that one of the things that he seemed to enjoy doing, was going out to eat?
Yes.
Trying different things?
As far as I can remember, yes.
Okay, and this is a reference to that then? You were talking about a restaurant maybe to go to?
I think I asked him if he likes Ethiopian food.
Okay.
Yeah.
Can we go down, ma'am, to the other part of that? Same chat from November 10th, 2011. Just so that we can understand the context of this, you guys begin to have a conversation about cannibals or cannibalism. What was that about?
I don't exactly remember, but it was some kind of a joke about, I think, African cannibal tribes. Yeah.
Okay. Pretty varied conversation topics that you'd have in these G-chats.
Yes.
Can we get 14, ma'am? This is from a November 28th, 2011 G-chat. There's a reference here to a class that I think, are you both taking the, can you back that up, I'm sorry, ma'am, and include Dev Bio in that? What's Dev Bio?
Developmental biology. So yesterday I mentioned developmental biology. So yesterday, I mentioned that we were taking the core classes in the first semester, and that was one of the parts. I think it was the last part of the core class.
Okay, and you were taking it together.
Yeah.
This is in reference to that, and again, we're talking about the defendant's sense of humor in writing here. Tell us what this is in reference to.
I don't exactly remember what cleavage means in cell biology, but I believe it is when cells cleave and separate. One cell separates to make two cells, and that's called cleavage, but I don't exactly remember what it means, so.
Does this end up through the rest of this chat, or at least a good part of it, become a bunch of innuendo back and forth?
Yeah.
Okay. Can you go to the bottom of that page, ma'am, on 14, that last part? This again was from November the 10th, November the 28th, 2011. And the defendant references, you got to move into my new lab today, though. Do you remember who that lab was that he was moving into on November 28th?
I don't remember the name of the professor, but I believe it was his second rotation lab.
Did he ever express to you his thoughts on the first rotation lab?
I remember him saying he liked the first rotation and he would probably join that lab.
That was the one he wanted to join?
Yes.
Now, in this second lab, if you could go, ma'am, to the top of page 15. You ask him if he's excited about it. Do you remember what he tells you?
He said he wasn't really excited about it.
Can you go to the bottom of 15, ma'am, that starts with I'm kind of? You guys talk about that class again, the one with all the cleavage, and he references I'm kind of sick of developmental biology. Was that a sentiment you shared as well?
I was kind of tired of the whole first semester of course. We had classes at 8 a.m. 5 days a week, so.
Was that pretty consistent sentiment?
Yes.
Stressful time?
Yes.
Ma'am, 17. This now is a chat from January the 10th, 2012. So this is after break.
Mm-hmm.
You both have returned. Is that right?
Yes.
There's a reference in here to B-movies and snuggling. Is that consistent with sort of the things that the defendant liked to do?
Yes.
Other than go out to eat?
Yes.
Okay, thank you. Page 18, ma'am. There's up there next to all those. I'm sorry, I misdirected you, ma'am, on that prior sheet. There's a reference here to serial killers. Tell us what that's about.
So in high school, I read a few books on serial killers, and thus I sometimes have bad dreams about them, and especially when I'm extremely stressed out, and I have issues sleeping in that case, and that's what it was in reference to.
Okay, and now, ma'am, the bottom of that page 18, please. You begin to have an exchange back and forth here, seemingly about PhDs versus master's degrees. Do you recall that?
Yes.
Tell us, put this in context for us. What's important about this? That's a little bit hard to read, but we'll get to it. Well, now we can't read it at all. Okay. What's the conversation going on there between you and the defendant?
From what I remember, we are talking about my PhD versus his PhD, and how with my former degrees and what the PhD I am doing, I can get away with a master's or even an undergraduate degree and get a good job. Whereas in biology, you need to have a PhD to get a really good job.
And is neuroscience considered part of biology?
Yes.
And so absent a PhD, it would be a struggle?
I'm not sure. I don't know the field of neuroscience that well, but you would definitely get a much better job with a PhD.
And this is the defendant's reference to you about that exchange?
Yes.
Can you go to page 22, ma'am? Anytime, sorry, at any time, day or night, and then a little bit below there? Or, yeah. This is from a G-chat from January 25th, 2012, and there's some discussion of you having some sleep issues. Do you recall
Yes.
that? In this part here, he references having an Ambien that he might give to you. What I want to ask you is, in that context, had you ever seen other drugs, or prescription or otherwise, in the defendant's apartment?
All I remember is seeing Vicodin in his medicine cabinet. I don't remember any other drugs.
Ma'am, can you go to 24? Now, at some point, ma'am, there is an exchange that takes place here between you and the defendant, seemingly about a meeting that he had with his advisor. Do you recall that?
Yes.
Tell us about that.
He mentioned that his advisor had called him in and asked him to jump in the pool, per se start having social interactions and discussions in the lab.
And was that becoming an issue for the defendant?
As far as I know, yes.
Now listen, during the time that you were with him, did the defendant express to you concerns about his social anxiety and ability to interact with people in public?
Yes, he recognized that he had issues interacting with people in public, and he thought other people were judging him for it.
Now, did you make a recommendation to him based on these expressed concerns?
That and some other concerns he had, I told him to go see a therapist. It might be better for him. It might help him.
Now, given how you've described sort of this entire graduate school program, was it uncommon for students to access student mental health?
Not at all.
Mostly anxiety, stress issues that you're aware of?
Yes.
Foundation?
Sustain us to foundation. You can lay the foundation as to how she knows.
That's okay, Your Honor. I'll move on. Thank you. I wanted to ask you about this word to see if you know what it means. The defendant says to you, science appears to have shifted from guys working alone in a dark room to some huge, do you know what that word is?
Interactome.
Yeah, what is that?
Again, I'm not from a biology background, but I think an interactome is basically a lot of different parts.
Excuse me, Ms. Dada. Objection, speculation.
The objection is sustained in part. She can't testify about what the defendant meant, but she can testify about what she understood by it. So, does that make sense?
Yes.
Okay, what did you understand? What did that mean to you?
So in my understanding, interactome is different parts of a working body of cells or a cell interacting together, and the whole system is an interactome. That was my understanding, so I think he meant that.
Hold on, this is where you cannot say.
Okay,
Yeah.
that's fine. Yeah.
That's okay. Thank you. There's a place more towards the bottom, ma'am, of 24. There are several references to the rapist, and we touched on this yesterday. I just want to confirm for you. Is this the word therapist separated to track that SNL skit?
Objection, leading.
Overruled?
Yes,
Okay. And did you end up adopting that sort of humorous reference to therapist as well?
in the chats.
Okay. 25, ma'am. There's a portion down here where the defendant expresses to you some symptoms of an illness that he's going through, and this is for January 26, 2012. Do you recall that?
From the chats, I do.
Is this the only time you recall the defendant ever expressing to you any physical issues?
From what I remember.
Page 26, ma'am. There's a reference here by the defendant to psychotic delusions. On the next line, which we only catch a piece of, there's reference to paranoid. You reference paranoid support group. Are you referencing psychiatric things, or is this just banter?
My understanding was it's just banter.
January, 28, ma'am. Can you go up to the part I've pretty much made up?
I think this says January 30 under.
Yes, and thank you for correcting that. On the record, Judge, I had started to say the date, and I changed to the page number for us internally. It's page 28. Your Honor is correct. It is a January 30th, 2012 G-chat. Thank you, sir.
All right.
As of January 30th, 2012, is this a reference in your understanding to that lab that he had started that he wasn't that excited to start?
The second lab, yes.
Next page, ma'am, 29. Did the defendant go into great detail in describing to you any prior family group therapy that he may have had, or just passing reference? How did he?
He did not go into great detail. In December, I think, from what I remember, in December, he had mentioned that his family had moved from Northern California to Southern California when he was a kid, and his mother had issues coping with it, and thus they went to group therapy.
Okay, thank you. Anything else he added about was it effective or not? Anything?
I don't remember, sorry.
That's fine. 30, ma'am. Right here at the bottom where it says, yep, that's right. Thank you. There's reference in a couple different places to Dom or Dominion, and you touched on it yesterday, but I want to confirm. What is this a reference to?
It's a strategy card game, so almost like a board game.
Could you play it two-person, or is it 3, 4, 5?
You could play it two-person. It's much better to play it more than two people since it's strategy.
Now, this is a chat from February the 10th, 2012, and you can take that down, ma'am. Thank you. What is going on your side of this relationship?
At that point, I was pretty sure I wanted to break up with him, so I was trying to distance myself from him.
Why were you thinking of breaking up with the defendant?
I had been dating him for a few months then, and I still didn't feel extremely connected with him and didn't see a future with him.
Okay, but you don't tell him right away.
No, I was waiting for the best time.
After this G-chat, there's a Valentine's Day. Do you remember that?
Yes.
What did you guys do for Valentine's Day?
He cooked me dinner, and we watched something. Yeah.
Uh, 32, ma'am. Thank you. This was a little bit less than 2 weeks after that last G-chat and a little bit after Valentine's Day. This is a reference from the defendant that we can read here. What is he referring to, and what, based on your interactions with the defendant, what's going on here?
So his second lab rotation had just ended, and apparently it didn't go well, so he was saying that he won't be joining that lab. He knows that, so.
In fact, right above that, there's a reference, right below that, sorry, I'm messing you up, I'm sorry, ma'am. He describes the professor's response to his performance, doesn't he, right here on this bottom part?
Yes.
Now, that's February 23rd. Thank you, ma'am. You can take that down. How soon after this do you break up with the defendant?
I don't exactly remember, but probably a few days, within a few days.
And you did it by, you had told us you had either texted him or somehow gotten in touch with him. Did you go over to his house
Yes.
to tell him? And how did he respond to that?
He was calm. He seemed he seemed a bit upset, but he didn't show any extreme reactions. He was calm.
Did he ever show any extreme reactions?
Not that I remember of.
Now, there's a G-chat from March 5th. That's the next one. I don't need to see that, ma'am. But what I want to ask you is, after you break up with the defendant, is there a drop-off in the amount of G-chats and other communication that you have with him?
Yes.
Are you still seeing him in class?
Yes.
Now, how long after you break up with the defendant is it before some kind of relationship starts back up?
Maybe a week or so.
How'd
week
that
or two.
happen?
I went up to him to ask him if he was doing okay and whether he wanted to be friends.
And?
And we became friends. And
Look, and again, I don't want to be indelicate here, but I'm going to use a colloquial phrase here. Friends with benefits? Is that?
Yes.
Okay. And how long did that last?
until early April.
Okay. Can I get 35, ma'am? This is from March 21st of 2012, and it's just how the defendant signs off to you. Is this pretty consistent, again, with sort of his kind of humor?
Yes.
During those few weeks or even up to a month, and you can take that down, thank you. During that time, was your relationship different than it had been before, and if so, how?
We hung out more, yes. We hung out more in a group versus a lone setting. And I was more distant with him and less romantic with him.
When you spent time together alone, was it at his place, your place, still both?
I think still both. I don't exactly remember.
Okay. 36, ma'am? This is a March 25th, 2012 G-chat. And it appears you reach out to him with this exchange about Rickrolling. Tell us what that means.
So a few years ago, YouTube, the website, played this April Fool's prank on basically everyone who accessed YouTube. Any video you would click on, it would go to Rick Astley's Never Gonna Give You Up. And so that, and YouTube coined the term Rickrolling for that. So I believe his status, so in Gmail you can have status messages, and his status messages was that video, that Rick Astley is never going to give you up, and that's what I was referencing.
Okay, and then you go on to discuss sleeping and video games. You recall that?
Yes.
And then you get into a discussion where the defendant brings up to you that what he wants to do is evil. Do you recall that?
Yes.
Now, at the time that he references that in the chat, and we'll get to see that, what are you thinking?
Initially I was thinking he was just messing with me. He was joking.
And then throughout the conversation, does that sense that you have change over time?
Yes, he starts talking about justice. At that point, I start thinking maybe he's serious, but it seemed very philosophical and discussion-wise.
And do you end up over the course of this chat engaging with him in sort of a philosophical back and forth?
Yes.
Now, at some point during this conversation, do you express to him, look, I don't track what you're saying about how this philosophy works?
Yes.
All right. And it goes on here for a few pages that we're going to see. But then, do you recall how this chat ends as you're going back? By the way, do you have any sense that this is imminent or there's a plan in place or anything like that?
No, not at all. This was the first and the only time he had mentioned something like that, and it seemed very philosophical.
Okay. Can we get 39? Yeah. Is this how that chat ends between the two of you?
Yes.
Is that top reference again to the game that you had described to
Yes.
us earlier? And then, do you remember if you ended up coming over to play Dom or Dominion?
I don't remember.
Does this ever come up again between the two of you?
So I showed this chat to Ben Garcia because I was a bit concerned, and we decided to go talk to him. I don't remember when we talked to him, but we asked him if he was talking to his therapist about this philosophy, and he said he was.
Okay. And then what I'd like to do, Your Honor, with the court's permission, is then publish the individual copies, give the jury a chance to review it, and then come back and ask some final questions to wrap up sort of the end of this portion of direct.
All right, is there any objection, Ms. Brady?
Can I just speak to Mr. Brockler real
Yes.
quick?
Let me turn the thing over here.
Yeah, you both should turn your mics off.
Before we do that, Your Honor, Ms. Brady has pointed out, and I think this makes a lot of sense for me to highlight, that throughout these chats, there's a dsherlockb@gmail.com. Is that the defendant?
Yes,
And there's someone called me. Who is me?
that's me.
Okay,
Yeah.
good. Anything
All right.
else, ma'am?
No objection. Thank you.
Without objection, we're going to go ahead and publish Exhibit P-TR-649. Members of the jury, we've used this method before where we hand each of you a copy of an exhibit to expedite the publication of the exhibit. So that way you don't have to pass around a single copy. That would take a lot longer. Please keep in mind that once you're done reviewing it, we'll take your copy back from you, and only the original will be introduced into evidence. I want to remind you as well that any statements in this exhibit by Ms. Data have been admitted for the limited purpose of placing in context and making intelligible the defendant's statements. And so the statements by Ms. Data in this exhibit have not been admitted for the truth of the contents of her statements. They have been admitted for the limited purpose that I just mentioned, and you should not consider them for any other purpose. Does everybody understand? Great, and everyone's saying yes or nodding their head yes. With that, then, why don't you hand the copies of the exhibit to my staff, and then Ms. Gerlings and Ms. Zagel will distribute them. Thank you.
Your Honor, given the length of this particular document, would the court permit Ms. Data to step down until they've collected up all the copies again?
Yes. Yes, you may step down. I'll give you folks a couple more minutes, okay? All right, the record should reflect that the jury just finished reviewing People's Exhibit P-TR-649. And Ms. Data may resume the witness stand, and then you can complete your direct examination, Mr. Brockler. Ms. Data, I remind you that you're still under oath.
Ma'am, thank you. Now, that last chat from March 25th, 2012, you in the past have used a term to describe it as maybe delusional. Is that fair?
Yes.
Is that the psychiatric term or just your term, like a street term, your term?
My term, I'm not an expert.
What do you mean by that?
That it did not make sense to me and it seemed a bit irrational.
Now, prior to that G-chat on March the 25th, there was St. Paddy's Day. Do you recall that?
Yes.
Did you and the defendant and some others go out for St. Paddy's Day? Do
Yes.
you remember where you went?
Somewhere downtown. I don't remember the exact places.
Now, you have previously told us that you were sort of special friends during this period of time, but it was after you were romantic. Is that accurate?
Yes.
Was there an incident that took place at the St. Paddy's Day get-together?
Yes.
Tell us about it.
So someone came and tried to talk to me, and I found out later that the defendant had gone up to that person and had told the person that I was his girlfriend.
What did you do in response to that information?
I later, outside, not in the bar, confronted him and reminded him that I wasn't his girlfriend at that point.
And when you say him, you're referring to the defendant
Yes.
in the blue shirt over here?
Yes.
Did he have any response for you?
I don't remember what his response was.
Prior to that interaction where you told him that you were not his girlfriend, had he ever expressed to you that he loved you?
Yes.
Tell us about that.
At some point, he said he loved me, and I told him I cared about him as a friend, but I was not in love with him.
Had he told you at any point that you were his first real girlfriend?
No.
Prior to that March 25th G-chat, had the defendant expressed to you how things were going in his third lab rotation?
He had mentioned that his experiments weren't working, and thus it wasn't going well, but he wasn't that long into the rotation.
At some point, did you become aware that the defendant, through the therapist that you had talked about, had been prescribed any medication?
He had mentioned that he was taking some medication.
Do you remember specifically what it was?
No, he didn't tell me.
Now, during the time that you had an opportunity to observe him, did you notice any differences in the defendant?
Not particularly. He seemed to loosen up around people a bit more, but other than that, no.
Did you ever see any big highs or lows or big changes in his demeanor or presentation?
No,
Did his personality change at all?
not that I remember.
Did he ever express to you that he was suicidal?
No,
Did he ever tell you about any past suicide attempts?
no,
Did he ever express to you feeling manic?
Manic, you meant? No.
Yeah. What, did I not say manic?
I heard Mac, so that's why I asked.
Did he ever tell you he was Mac?
No,
Okay. Did he ever tell you he was manic?
no,
Okay. Did the defendant ever, let me back up. Did you ever reach out to the defendant after you'd broken up that first time, or even the second time, ever, and express to him that you were going through 5 stages of grief?
I don't remember doing that.
Does that sound like you?
That does not sound like me.
Did the defendant ever text to you anything along the lines of the thorn in my side was worth the rose?
No,
Did you ever get a text from the defendant that I don't see the glass, I see around or through the glass, or words to that effect?
I don't remember any such text.
Do you think you would remember such a
I
text?
think I would.
Now, you had an opportunity to, you had an opportunity to continue to see the defendant in class throughout this whole period of time?
Yes.
And you know what? I forgot to ask you about one thing in particular. After this March 25th chat, did you sort of still kind of continue to see each other for a bit?
I don't remember the number of interactions we had, but we stopped talking about a week or week and a half after that.
Sometime in April, then, did the defendant contact you with a change in your relationship?
Early April.
Tell us about that.
He contacted me saying that he did not want to be just friends anymore, and I did not want to be anything more than friends at that point, so he did not want to continue talking to me.
Either in that conversation or a future conversation, did the defendant ever reference someone named Hillary?
Yes.
Tell us about that.
He also mentioned that he was hanging out with Hillary at that point, and thus I respected that.
Was that, in your interpretation, was that an effort to explain why he wasn't going to hang out with you anymore?
Yes.
Now, your class that you had that ended in May, do you remember about when in May it ended?
Mid-May, sometime.
Was there a presentation component to that class?
Yes, we had to present a final, we had to choose a topic and do a literature survey of sorts and present something on it.
Is that different than an end of the rotation presentation?
I would say it's lower pressure and less important, not less important, but lower pressure, I would say.
Did you ever, prior to this mid-May presentation, ever see the defendant give any presentation in class?
No,
This was it?
this was it.
Describe for us that presentation, if you recall.
From what I recall, it was extremely awkward. He wasn't good at engaging the audience, and it was extremely awkward.
Is that what made it awkward? The presentation, I guess the manner of presentation?
The presentation style, yes.
Let me ask you, how about the substance?
I don't remember much of the content of the presentation.
Did you have any lasting memories of it being babbling?
No,
Like disjointed or disorganized, or
not that I remember.
guys not eating paint chips off the wall or talking crazy, nothing like that?
No.
Did you see?
Objection, Your Honor. It's argumentative.
Overruled.
Did you ever remember seeing any bizarre hand or arm gestures or anything like that?
Not that I remember.
Just seemed awkward.
Just seemed awkward.
Prior to that, by the way, is that the last time you would have seen the defendant in class?
Yes.
Is that the last time you saw him at all?
Yes.
Up until that time, do you ever recall him missing a class?
I don't remember, but he wouldn't have missed a lot of classes, I would say.
Do you ever remember him appearing physically different to you during that time leading up to mid-May?
No.
How about dressing differently?
No.
Behaving differently in class?
No.
Any different hygiene?
Until April, no.
Yeah. When was the last time you think you spoke to him?
We had a conversation early April. I might have said hello in class sometimes.
And did he respond?
I think so.
At the time that he gave that presentation in mid-May, did you ever know the defendant to have owned a cell phone stun gun?
No.
How about a gas mask?
No.
Did you know if he was purchasing a gas mask?
No.
Tear gas?
No.
Weapons?
No.
Do you know how much equipment he had amassed for a future crime?
No, I had no idea.
At any point, did you ever perceive the defendant, in your opinion, to be dangerous?
No.
Can I have a moment, Your Honor?
Yes.
Blank stares, Your Honor. I have nothing further. Thank you.
All right, would counsel approach for just a moment, please? All right, members of the jury, it's 10:30, so it's time for our morning break. Please keep in mind all the advisements I've been giving you throughout the trial. They apply during the break. I'll see you back here in 20 minutes. Thank you. Ms. Data, you may step out as well. You're on break. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom and Ms. Data has exited the courtroom as well. Where's Mr. Bruckler? Oh, there he is. Okay. Sorry. It occurred to me that it may be appropriate for me to give the jury an instruction that any testimony from Ms. Data relating to that any testimony from Ms. Data about the defendant's behavior or demeanor should only be considered as her observations of his behavior and demeanor and not as any opinions related to anything. And that's a similar instruction to what I gave in the past with respect to the question that was asked multiple times about did the defendant appear to be detached from reality. I want to make sure the jury is clear that this witness cannot offer any expert opinions about mental health and that she can only talk about observations of demeanor and behavior. And that's the only way they should understand her testimony. But before I give it, I want to make sure the parties are okay with it. Do the people have a position on that, Mr.? And the reason I'm asking about this is because there was a question about whether the defendant was eating paint chips or talking crazy, I think was the question. And I want to make sure the jury doesn't take the answer to be an opinion about the defendant's mental health. It's only an answer related to this witness's observations of the defendant's demeanor and behavior, and that's the only way the jury should understand that question and that answer. Mr. Brockler, do you have a position on that?
I don't know.
Ms. Brady, do you have a position on that?
I don't object to the court giving that.
Okay, I'll give an instruction along those lines. I'm not going to highlight the specific answer because I don't want to repeat it, but I'll give an instruction along the lines of what I just mentioned. All right, enjoy the morning break. I'll see you back here in 20 minutes. The court will be in recess.